Hi guys.
Hi, Arabella.
Hello.
Arabella.
Oh, how are we all?
Tired.
Yep. Yep. Absolutely. We'll just give it a few more minutes. Then we'll kick on.
How's it all settled down up around Cairns? Still flooded?
No, we're not flooded, but I think a few suburbs are pretty badly damaged, unfortunately. So there's still cleanup, and I think there'll be a lot of building projects this year. Yeah. I say that
Still
though,
down in
and
Brisbane from a few years ago.
yeah. January, I think, has just been the month for crazy weather everywhere, unfortunately. Very grey and dreary at the moment, looking out my window, I have to say. So I think we're in for a bit more, possibly another cyclone, I heard today too. So who knows?
Yeah, I heard that too.
Yeah.
Hmm.
Yeah.
It always seems to be up north, and because I'm
Yeah.
on the Sunshine Coast, and we just miss everything. So
Yeah.
it's a shame because everything's. I mean, it's good that we don't get the cyclones, but everything can be so brown.
Yeah. Yeah. A bit of rain can probably do a bit of good. Hey. Well, I think we've got a little bit of a smaller group today, which is absolutely fine. We're looking this week 9, at grants of representation. And as I said last week, these weeks, particularly week 9, they're very practical weeks. And if you go into this area of practice, obtaining grants of representation, grants of probate, letters of administration, I suspect it will be quite a core function of your practice. So before we jump into the tutorial, I just wanted to give you all a little bit of an update in relation to the 2 assessments. And I will just apologise to people. I have been quite slow on my emails the last week or so. I have no excuse other than to say it has been quite a hectic week in my full-time job. So I am planning on catching up this weekend. So I thank you for your patience. What I have had a lot of questions about is the second assessment, and also questions around feedback from assessment 1. Where we're sitting with that currently, I still don't have all assessments submitted. So largely we're still in the same position as last week. I've made further inquiries as to what to do and how to navigate this, because questions that I'm getting from students, it would be things that I would be sharing and discussing in the group feedback. So leave this with me. I'm very conscious that the second assessment piece is due to be released in a couple of weeks. And I'm actually not 100% sure what to do in this sort of particular situation that we find ourselves in. So I am looking into it, but at this stage, I don't have a date for a group session and the feedback. If we have to, I'll just run a separate sort of workshop tutorial sort of as soon as possible once I can, which will be recorded. So if people can't attend, at least there will be the recording, and there'll be a guide as well that people can refer to. So that's where we're at with assessment 1. Sorry, I don't have better information for you all.
Arabella, will you be able to put up
Yeah.
an example of what a good one looked like as well, or not really, just so that we can see where we sort of fell behind a little bit in some regards of what a good will, in your view, looked like, or what a...
I'm not going to give drafted examples, but rather what I will put up is what we expected you to cover off on in the will, power of attorney, and in your letter of advice. I think that will probably largely address, what a good advice or will looks like. Yeah. Looking then at assessment 2, I had planned to cover this perhaps next week, but given the questions and sort of where we're sitting with the assessment 1, I thought I would run through some key information tonight. So this will also be, I'll do up an announcement in the feedback, so you'll have it in writing to refer to as well, and obviously the recording. So that everyone knows, assessment 2, the details of assessment 2 are in Moodle already under the assessment tab, as is the criteria rubric. Now, if you haven't, download and read the criteria rubric. The criteria rubric was there for assessment 1 and it's there for assessment 2. So that would be my first recommendation to you all. And also moving forward with other subjects that you're studying. If there's a criteria rubric, most lecturers or unit coordinators or whatever we are, will load that for students. It is a written assessment, and it's 3 questions. Each question has an equal weighting of 20%. So that's what we're looking at. The total paper is worth 60%. So it's your major assessment piece. I have had some questions around if I can provide copies of past exams. This year or cycle that we've run this subject, we have changed and rewritten a lot of the assessment. So I don't have a past exam in this same format to give to you. What I have said is I'll have a look through previous material or papers that we used last time or other lecturers have used to see if there is maybe something that might be useful for you. If I think it will be of use, I'll pop it in Moodle, or I'll pop it in the forum and I'll tell you where it is. Otherwise, what I would recommend you do is go back through or look forward to the tutorial questions where you were given a scenario, pardon me, and where that scenario asked you to find issues and advise, because the assessment 2, your final assessment, will be in a very similar format to the scenario questions. I expect mostly for tutes, you might pull out your key issues, jot some questions, jot some thoughts, which is great. If you want something further, look back and provide written responses as though you were answering the question in an exam format. Week 12, if you haven't jumped ahead, does actually provide tips and tricks for the assessment piece. So week 12 doesn't contain any new succession related material. Got your assessment happening that week, but there is a lecture on how to succeed and do well. So if you haven't had a look at that yet, again, maybe jump ahead. I think it's only 5 minutes or so, the lecture. Listen to that, and that should also provide some further assistance and guidance. The release date is the 1st of February at 9 AM, I think, and it is due on the 8th of February. So again, all of this is in Moodle, but just to be clear. Talitha?
I was just going to clarify. So we won't have a Zoom session week 12, like a Wednesday night session, because like obviously there's no.
what I was going to say, just to jump around a little bit, I'm happy to to be here. And if people sort of have questions or queries, but there won't be a tutorial question, and I won't be answering questions around the assessment. I'll check in. That's what I've done in the past. I'll check in with Nicola probably and just see if she's happy for that to happen. Students have found that useful. So
Before the assessment's due, like the Wednesday night, is it? Is that?
sorry, Sleeth, you're just a little bit quiet.
Oh, sorry. Can you hear me better?
Yeah, that's better.
So the final assessment's due in week 12 though, right? So
Yes.
like the day before. So, okay.
Yeah. So it's released on the Thursday and then it's due the following Thursday. So you get a week. And I think I want to say that it's due at 6 p.m. on the Thursday, but again, it's in Moodle. Because this isn't, Emma, sorry, you've got your hand up.
So I was just going to ask, so week 11 will be our last lecture.
Yes.
Yeah, and the other thing was, you know how we're being given a week to do it? Like, do you envisage, if you have all your content and that, do you envisage how long would it take you to actually do it? Like, do you think we need to be taking days off work if we're working full time, or we can just do it at night? Like, how long is it? Is it like an exam that would take us normally 6 hours to do, or?
I think everyone's different. I mean, it's 3 scenario questions. The word limit's 2,500 words. So, I mean, people need to sort of plan their days accordingly. So I can't tell people to take days off work. But I think.
No, I was just wondering whether it was something that you envisaged it would take days to complete. Like, is that why it's been given over a week rather than in an actual exam, because of the fact that, it could take quite a while to do? That was
I think this is your major piece of assessment. I think what we're looking for detailed answers and good work. You are also required to reference, which, and I think in exam blocks or take-home exams, etc., that isn't the focus. So we do expect sort of, I guess, higher quality, because you are given that week, as opposed to if you're in a 6-hour, 3-hour block exam, where you might just be, I don't know,
Arabella,
rushing through an answer.
my exam has gone down to 2.5 hours now. It keeps getting lower.
Yeah, okay. Yeah, look, I don't know specifically. This was just a format that was suggested that I thought would be appropriate. It allows students, to spend time to provide well thought through answers to these questions, which I personally believe is closer to what you're going to be doing in practice. And also I guess it removes that sort of stress of having an exam within the exam block. So this is the format that was chosen. A week, I think, is more than reasonable to complete this. But I mean, like, look at, it's 3 questions, 2,500 words. You are given a week, so we want this done properly and in detail. Do I personally think people need to take time off work? No. I think third years, you've all got jobs, you should be able to plan your time accordingly, but I can't comment on what people feel comfortable with. I think it can be done in a week. So did Nicola, so did the team that put this together. That's really all I can say in that regard. Alison?
I'm just double checking, does it cover the content from every week?
Yes, so touching on that, it will cover weeks 1 through to 11. Obviously, we have touched on weeks 1 to 6 in our first assessment piece, But that doesn't mean to say that weeks 1 to 6 won't be in the questions. So you really should have a good understanding of all 11 weeks that we've covered. What else can I say in relation to that? Look, I think I can say this safely. I'm not expecting people, you know, for example, in response to one of these questions, to go into significant detail about why will is important, because we've covered that in detail in our first assessment piece. So things like that, think about. If there's some clear other issues in the scenario that you need to address, address those in detail is what I would say. But yes, weeks 1 through to 11. Yep. Now, because this isn't a block exam, it's students may seek extensions. I would suggest that unless there is a very good reason for an extension, which happens, I understand that, everyone understands that. But as much as possible, try and get this done in the week so that they can be marked and handed back to you and your grades can be released per the schedule. If you do need extensions though, as I said with the first assessment, reach out to me as soon as possible so that I can plan and you can plan and we know what's happening. They're the key points, and I will touch on, and I will put those in writing as well. But any other questions around this, the assessment 2? Nope. Cool. But as I said, do read the criteria rubric and do have a look at the information on Moodle. And I will have a look to see if there is any sort of similar past papers or scenarios I can provide for practice. Otherwise, look at your tutorial questions. All right. So then if we are jumping into our material, grants of representation, our tutorial questions, we'll move through these scenarios fairly quickly, I suspect. I don't have a real life application. I will get my assistant to redact one just so we can have a look at that as an example. So that will be on Moodle. But what I will do, which I think will actually be slightly more helpful from a practical perspective, is I'll show you where all of the court documents are on the court website, and we can have a look through those, because what's on those forms is largely what's going to be included in an application that a solicitor prepares. All right, so you've probably worked out by now too that you need to have reference to the UCPR, specifically Chapter 15, to assist you with ascertaining, particularly for grants of letters of administration on intestacy and grants of letters of administration with the will annexed, who can actually apply for those grants. So just make sure that you're across Chapter 15. Looking then at the scenarios that we have in our workshop question, let's just work through these together. Feel free to just jump in with your thoughts and answers. So 1A, a person dies leaving no will. They're survived by their spouse, and the sole asset of the estate is a property owned jointly by the deceased and the spouse. I guess firstly, if you were advising your client, would you be saying they need to get a grant? And if so, why? Ella?
I I would be saying personally no, because with the sole asset being a property owned jointly with the deceased, the surviving spouse is going to receive the deceased share in the property anyway, as soon as their death. If it was like a property held as tenants in common, then it would probably be necessary to apply for a grant. But I believe maybe no, if this is the biggest asset. And they haven't also mentioned any other family members as well, which might impose, the potential to apply for a grant, to, I guess, protect yourself of a claim.
Yep. Great. Anyone take a different view to Ella?
No, I agree with Ella. The principle of survivorship, the property vests with a surviving partner, so probably no need.
Yep. Yep. Great. I take the same view. Looking then at 1B. Sorry, my dog's going crazy, so if you can hear that, apologies. A person dies leaving no will. They are survived by their 3 adult children, and the major asset of the estate is a superannuation death benefit held with Q Super. A binding death benefit nomination has been made in favour of the 3 adult children and is valid. The only other assets in the estate are bank accounts with the Commonwealth Bank. What do we think? Do we need to get a grant? If so, why? Or why not?
Having 3 beneficiaries, wouldn't you apply for a grant of letter of intestacy because there's no will?
So we've,
because it says that there are multiple bank accounts.
So yep, so there are bank accounts. So there are other assets in the estate that will need to be pulled in. Yep.
I think like I agree with what you're saying. I think what you're saying is like, because there's 3 beneficiaries, then it creates that potential risk and gives you more of a reason to apply for a grant, as well as, I guess, in the way of priority, they're all children and they're all receiving, I guess, sorry, that the level of priority the court would need to decide, because they're all children. Or no, sorry, it would be whoever gets the most beneficial interest, wouldn't it?
So if we don't have a will, we're looking at the intestacy provisions. So we've got 3 adult children, and we can assume that there are no other potential beneficiaries on intestacy. So here, if we look to the, sorry, let's go back a step. There's bank accounts. So there are assets that need to be called into the estate. So our first step may be to make inquiries with the bank to see what do we need to call in. Usually banks will require to cite a copy of the will or a grant before they'll release assets. So assuming that the bank has a bit of cash, they're going to want to see proof that they can release the asset, the funds, to the estate.
So they'll need a grant of administration, no will.
That's right. So we'll be getting a grant of letters of administration on intestacy. And Ella, you were then discussing who would apply for that. Now, if we look to the UCPR, if we look at 610, thank you, Bill, we've got our order of priority and who can apply. So there's no spouse, and the deceased's children are the next cab off the rank. So all of these children have an equal priority to apply for a grant of letters of administration. What they may decide is one to apply, or they may apply jointly. That would be something that you would discuss with the children and take instructions on. So that was 610 in the UCPR, where we're dealing with an intestate estate. Now, just quickly, with respect to the superannuation, because we've got that binding death benefit nomination and we're told that it's valid, those funds should be able to be paid directly to those adult children beneficiaries. Sorry, Talitha.
I just wanted to clarify because I just couldn't really interpret the UCPR. So in the situation where there's multiple, will the court grant those letters to multiple applicants, or is it best if just like one of them applies?
So you can absolutely have multiple. So here, if all three wanted to apply, they would bring the application as joint applicants, and the grant would be issued to them, you know, all three of them, they would be named as the administrators of the estate. Or if only one decided and the other two children perhaps renounced, that, you know, they didn't want to do anything with it, happy for perhaps, you know, the oldest to look after everything, then you would make your application, you know, the eldest would make the application, you'd annex the renunciations showing that the other two didn't want to apply, they don't want to take on that role, and then the court would issue the grant to the sole applicant. So it depends on, it really depends on your client's instructions on how they want to proceed, because they have that equal standing, that same priority to apply.
And if they all apply, is it the same as we were talking about last week, where then all the decisions have to be, they all agree? So it would be a little bit of a pain in the butt, like depending upon if they all lived in different places. Like from a practical standpoint, if you're giving someone advice, you might say, look, if you're all getting equal shares and you all like each other and you're all happy, it's probably just easiest for one person instead of like everyone signing the bank form and everyone
Spot on.
around. Yeah. Okay.
Yeah. That's the advice I give regularly to people. Obviously, though, there does need to be, I guess, you know, really from a practical perspective, that level of trust between the beneficiaries. But as you say, when you need 3 signatures on a form, and let's say here we've got 2 bank accounts, it just increases costs. You know, if one administrator is overseas or is just slack, it can just really, yeah, be a real pain. Yeah. So always good to have the conversation. Yeah, absolutely. All right, now looking at 1C, a person dies leaving a valid will, appointing their spouse as the instituted executor. The spouse predeceased the deceased 12 months ago. The deceased, though, is also survived by their elderly parents and a sister. The assets of the estate include real property, significant bank accounts, term deposits, and shares. The estate is divided equally between the elderly parents and the sister. So in this scenario, we have got a will, but the executor has died, and it appears that there is no alternative executor appointed.
So they'd be applying for a grant of letters of administration with the will annexed.
Yep, spot on. So just with respect to who can apply in those circumstances, again, we look back to our UCPR, and with this time we're looking at 603, and this is the priority for letters of administration with the will. So we're told here, we've got elderly parents and a sister. So who are you going to? Sorry, Bill,
the most Yeah, the sister would be the most appropriate because the parents are quite elderly and maybe lack the capacity.
Mm-hmm. Yep. So you'd be having that conversation, similar to what we just discussed, really, would be having that conversation with the beneficiaries, so the parents and the sister. And because on the information we're provided, it seems to be a slightly more complex estate. There's going to need to be a bit of work done to call in these assets. So as Bill said, it may actually be most appropriate that the sister applies for a grant of letters of administration with the will annexed. Any other thoughts on this scenario? Anyone think differently? Nope. Cool. Now I think D.
I was just going to ask a question. In real life, you know, if this person is able to make the application, but you'd be saying that as the solicitor, you do all the paperwork for them and they just sign it on their behalf. Is that right? You don't expect them to actually do it.
So the applicants still need to sign the court documents and make the application. But yeah, as a solicitor, you would be preparing the documentation for them. They still need to sign it. The grant is issued in their names as the administrators. But as is common, they will instruct a solicitor to carry out you know, the administration of the estate. So the solicitor, for example, would write to the bank, collect the forms, but the administrators would still need to sign and provide instructions. So it's much easier with a solicitor if it's more complex, arguably, but the administrators still need to be involved and provide instructions and sign documents. Ella?
Would the applicant need to obtain renunciation from the parents, or is that in letters of administration and intestacy?
Yep. So in this case, you usually need to, you don't need to clear off people with an equal standing. But sometimes as a matter of course, you might address it in your supporting affidavit material. So if we look at like 603, for example, with respect to letters of administration with the will, in this scenario, we're looking at residuary beneficiaries sort of as the people with standing to apply. So here, the parents and the sister they all have that equal standing. So one of them or all of them could apply. If you've got someone higher up the chain, so if there was no will in this scenario and we had parents and a sister, we'd be looking back at 610 and you'll see that parents have a higher priority to siblings. So the parents would need to formally renounce, and then the sister could make the application as she would then be next in line, so to speak, to make the application.
Okay, thank you.
All right, if we look to D, so I think this is an extension of our last scenario. Assuming the grant of representation obtained, no, maybe not, in question 1, I'm going to say C, in 1C is revoked because a later will appointing the sister as executor is obtained. So we find another will. Discuss the effect of revocation, particularly in relation to any debtors of the estate and any debts incurred or paid by the administrator appointed under the original grant. Thoughts?
Wouldn't they be valid provided they were received in good faith under section 53, 1, 2, and 3?
I'm not sure, are other people having problems with Bill or not? Okay, it's not just me. Yeah, sorry, Bill, if you can hear us, your internet might be having a little bit of a conniption, but I heard section 53 of the Succession Act, pardon me, that's right. So provided that the administrator, for example, has paid debts in good faith, they're not going to be liable or sort of suffer any loss if the grant is revoked. What is really important in these situations is understanding when the administrator, when they become aware that the grant is to be revoked, or I think one of the examples in the textbook was if the executor finds out that there is a later will, for example, in this scenario, that the moment that they have that knowledge, they act appropriately, and they don't, for example, distribute the estate or pay other debts, ignoring the fact that there is a later will that needs to be admitted to probate. So section 53, have a look through that, but it really comes down to acting in good faith, acting reasonably, and as soon as an administrator or an executor is aware that the grant is to be revoked, acting accordingly, so not taking any further steps. I think in those scenarios, though, the caveat on that might be if non-action could potentially result in a loss to the beneficiaries or to an asset of the estate, you may be able to make an urgent application to the court, for example, for some directions around that. So,
Or could you apply for a limited grant?
Yeah, you could, particularly if the circumstances may suggest that there is going to be a dispute, perhaps as to the validity of a later will, if it comes to life. Yeah. Great. Anything else? No, cool. Any questions in relation to grants and the readings? I think as I mentioned last week, this is an area where there is a lot of information out there. So do a little bit of your own research. The textbook does go through sort of a lot of the different types of grants, limited grants that you can apply for. So that if you haven't had a chance to sort of run through those readings in detail, do. Some of them are quite unique and don't come across your desk frequently. But just as an example, you may see grants being made on behalf, particularly in the case of intestacy, on behalf of minor children. Quite often, or a common scenario perhaps that I see is we've got an intestate estate. The deceased had a child but had separated from the surviving parent of that child. And the minor child is the appropriate person or the person with priority to be bringing the application for a grant. So again, a minor child, that's quite a common scenario, or acting an attorney making an application. Limited grants, as Ella touched on, they're really useful, particularly in the context of estate litigation matters. If you've got assets that need to be sold or invested or called in, a limited grant can be very useful, and that's quite a common application to be made. So yeah, do have a look. I think some of the the readings for this week, it may have also been last week, they do address sort of a number of matters that we cover off in this unit. I think there's one or a couple regarding sort of testamentary capacity and what the court looks at, and then, you know, the orders being made, for example, a grant in solemn form. So if you're reading some of the cases thinking, how does this really relate to a grant? It's usually sort of way down at the end where the court gives the orders that you might be able to see why the court has made the grant that they have. So do have a look at those. If we don't have any other questions, I will share my screen and I will show you where all of the court documents are to prepare an application and to file. I will caveat this by saying most firms will have their own precedent bank, which may look a bit different to the court forms. But again, if you look to the UCPR, Chapter 15, these provisions really set out exactly what an application needs to demonstrate and the matters that you as a solicitor or the applicant need to address. So your forms that a solicitor might prepare probably formatted a bit nicer. In some situations, you'll be including more information relevant to your circumstances, but the same core information will always be included. So one would think after COVID and flexible work, I would be confident with screen sharing, but I'm not. All right. I know. I've lost all of you. There we go. All right. So just checking everyone can see, we've got Queensland Courts page with forms. Yes. Talitha is sort of nodding. Thank you. Excellent. So just to show you all how to get here, courts.queensland.gov.au. I think I ran through this maybe last week or the week before. If we go back to our home page, we scroll down slightly, you will see a button for court forms. If we click on that, we're taken to the forms page. Now, very helpfully, you can search by category. And for the succession lawyers, we have a wills and estates section. So now I'm hoping this isn't going to work. I had previously downloaded all of these and I thought I could be tricky and just bring them up, but perhaps not. Oh no, here we go. All right. So we'll look at firstly an application for a grant of probate. So this is a form 101. Now, if I bring this across, can you now all see a court document? Yeah, excellent, cool. Okay, so here is the application. So it's quite a simple looking document, and very helpfully in the footer, it tells you which rule this form relates to. So rule 597 of the UCPR. Now, if we quickly jump back to the everyone can see my UCPR? Yep, cool. If we jump back to the UCPR and we go to 597, an application for a grant. Proceeding for a grant must be started by an application. So we are complying with this rule by completing our form 101. So here, depending on what you are applying for, whether it's a grant of probate, you have a will and a codicil, or we're dealing with an intestate estate, will depend on how this top section is completed. But relevantly for us, the application states that we, the applicant, apply for a grant of probate of the will, and if there's a codicil, the codicil of the above deceased dated, so you would insert the date of the will, to be granted to me as the executor or administrator. And this is where, Ian, I think we were saying about executing. This is where the executor, the applicant, would sign the document. So the solicitor wouldn't do that for them. So this is really step one. This is our application. Now, applications must also have an affidavit supporting them. Oh no, we have not downloaded that. Apologies. So the affidavit that would support our probate application is Form 105 affidavit. And again, it's really user-friendly in that it tells you it's for your probate application. So if we click on that, I have downloaded this somewhere, it's telling me anyway. So here is our supporting affidavit. So again, this affidavit will comply with the requirements of Rule 602 in the UCPR. So what we are swearing to in this affidavit are the key pieces of information that the court needs to make this application. So if we read through, again, this is for your probate application, you're providing a clear copy of the true and original last will of the deceased. Now, you provide a copy and you also will provide the court with the original will. So if clients ask you, oh, I want the original will, I want to keep it, they can't. It's provided to the court. You swear to where the date of death and where the deceased died. So here it says address as per certificate of death. Now I will say, and Ella, I'm sure you've encountered this too, you must include the place of death exactly as it is listed on your death certificate. Even if the address isn't necessarily correct or it would be expressed in a different way usually, it must be as per the death certificate, otherwise the registrar will probably requisition you. A requisition means that the registrar is not happy with something or that they require further information to accept your application and to grant the grant of probate or letters of administration. Again, you'll be annexing the death certificate to your application. Now, here, if the death certificate suggests that the deceased was suffering from an illness or died of an illness that would impact their testamentary capacity, and there are rules around timeframes relating to the length of illness, you may be required to swear to your knowledge of the will maker's ability to make the will, and as to whether or not you, as the applicant, believe that they had testamentary capacity. So a really good example of this is if, for example, the death certificate says that the deceased's cause of death was Alzheimer's and dementia. You will need to show the court that notwithstanding that the deceased died of this illness and suffered from Alzheimer's, at the time they made their will, that they had testamentary capacity to do so. Solicitors sometimes take a different approach to whether you always include this information, sort of as a I guess, a cross-check, or whether you only include it in circumstances where there is a question potentially around testamentary capacity. So just something to be aware of. And very helpfully, as the precedent document suggests, if the deponent is aware of any circumstance which might give rise to any apparent doubt as to testamentary capacity, that circumstance should be disclosed. So again, if you have concerns, you need to address them in your affidavit. Similarly too, if the death certificate says, yes, the deceased died of Alzheimer's, but the will was done 10 years ago, deceased had a clean bill of health, that's the information that you would potentially include in your affidavit. Again, really depends on the circumstances. Sorry, this is my long-winded version of saying really depends on the circumstances. Find out, always check your death certificate. If there's a question of capacity, make sure you address it. If the applicant is the spouse of the deceased, we need to swear that they haven't gotten divorced, because that's obviously going to impact their appointment and standing and ability to make this application. Also confirming that the person is one and the same as the person named as the executor in the will. And this is also to where you explain why, let's say there's 2 named executors in the will, but only one is applying. This is where you would address the fact that the other person isn't applying, and you'd attach, for example, the renunciation. Or if they've died, you'd attach their death certificate. So you need to provide proof to the court as to why that named executor isn't applying. Really importantly too, the applicant needs to swear that they know of no matters which may bear on their standing as a fit and proper person to administer the estate. So in practice, you need to have a conversation with your client with respect to this and ensure that they can swear to this. For example, if, a good one is, if they've been convicted of fraud, if they have a really significant conflict of interest, this is all going to bear on their standing as a fit and proper person. So you want to make sure that you have that conversation with your client before swearing this affidavit. So that's the affidavit supporting your probate application. And then again here, your application needs to be sworn in the presence of a qualified witness, so Solicitor JP Comdec. And you would then, they don't have it, you would then exhibit your will and death certificate and attach this to your affidavit. The second affidavit that a person needs to complete is, let's see if I've got it, is your affidavit of publication and service. So when you're making an application for probate or letters of administration, you need to provide notice of your intention to do so. And this is done via form 103, which is your notice, which I'm bringing across now. So this is your notice of intention to apply, and this needs to be advertised, as I said, and this is made pursuant, again, if we look to our footer, pursuant to Rule 598. So if we just quickly jump back to our UCPR. So Rule 598, general notice of intention to apply. So a person other than the public trustee proposing to apply for a grant must at least 14 days before filing the application give notice in the approved form Form 103, of their intention to apply. At least 7 days before filing the application, the person must also give notice to the public trustee. And this can be given by way of post or fax, and email now to the public trustee. So, here's my form. Our 103 will be advertised in what's called the Queensland Law Reporter. And this is the approved publication. This is in, oops, oh, there it is. So this is our 103, and it simply says after 14 days from today, an application for a grant of whatever you're applying for, you'd insert the deceased details, will be made by name of applicant to the Supreme Court. And it provides the notice that you may object to the grant by lodging a caveat in that registry. So I'll just very quickly show you where you actually advertise. The Queensland Law Reporter. Here we go. Sorry, I'm not sure how to get rid of this band and I just can't see what I'm doing. Here we go. So, okay. So I'll just click on a random notice so you can see what it looks like. And of course, it's not what I want. Excellent. Admission, that would be why. Here we go. So here in the public notices, you can see this is for a grant of probate for a will dated the 24th of November 2020. We've got the name of the deceased's details, who will be applying. So we've got joint executors here, we've got 2, and it's being filed in the Supreme Court at Townsville. So we're giving the notice as well that anyone with any claims, advising them to come forward and substantiate their claims. And it's advising who it's been lodged by. So in this case, the 2 executors, they've engaged McCross and Anamia to assist with this application. So you'll see the reports are just pages and pages of notices to fulfill the requirements. So once you've filed your notice in the Queensland Law Reporter, you also send a copy to the public trustee, again, to comply with the UCPR requirements. And then you will complete what's called an affidavit of publication and service. Here we go, which is your 104. Great. Now, this affidavit will either be prepared by the applicant or in circumstances where you have engaged a solicitor, the solicitor will usually complete and swear this affidavit. So I've sworn many of these in my time. Basically, you are confirming that you've given the notice and it's been advertised in your Queensland Law Reporter. You insert the date that it was published. And also that you did provide a copy of the notice to the public trustee as is required. Pardon me. So again, this shows the court that you've complied with the requirements under the UCPR, and you would attach a copy of your notice to your affidavit. So that's for a grant of probate. The affidavit of publication and service, you will always complete, whether it's probate, letters of administration with will, or letters of administration on intestacy. But the thing that changes a little bit is the contents of your affidavit, because again, the UCPR is requiring you to complete or tick off different requirements. For example, with respect to, pardon me, your affidavit supporting letters of administration on intestacy, the court wants to see who survived the deceased and who has standing to bring the application. So that needs to be addressed in your affidavit. Similarly, with your LOA with will, the court needs to be satisfied that you have standing. So the contents changes, but the form largely stays the same. And there's key things that you will always need to provide and swear to. So that's just a very quick overview of what these applications will actually look like. Again, from a very practical perspective, your client will swear their affidavits, you'll collate the exhibits, so your will, your death certificate, for example, you'll pay your filing fee because nothing's free, you have to pay to file this with the Supreme Court, and it will be lodged in the court registry.
You have to enclose a registered post envelope because I've had the Supreme Court get extremely cranky with me before because I haven't enclosed a registered post. Like, it can't even be standard, it has to be registered.
Yes. So a very good example of the registry. Yes, you just, yeah, you're a slave to the registry and their requirements in this regard. I'm very lucky. So in the Cairns registry, for example, our registrar allows there to be collection boxes. So very practically, we will get an email from the registrar or the assistant saying you have grants available for collection, and we'll go down and we have to physically sign that they're being collected. So I will say that Queensland is a little bit behind the times. In Victoria, I think South Australia and potentially New South Wales, they have all moved to electronic lodgement and electronic form completion to a degree, and Vic have electronic grants. So you'll be able to log on to a portal with a unique code to actually access your grant. Queensland is all still paper-based. I think Brisbane have been trialling e-filing in the probate jurisdiction, but that is just specific to Brisbane.
Does it take ages for a probate to come back? So I feel like if it was e-lodgement, like online, I feel like it would, last and like make things so much quicker. Because even there's the portal where you can check like the status of the probate application, but it tells you nothing.
Yeah,
it's
very frustrating. Nothing. Yeah. So I think as a general rule these days, a grant of probate can take anywhere between 4 to sort of 6-7 weeks to receive back. I compare this to Victoria only because I have some experience there. I have had matters where I have filed my documents in the morning and I've been given a grant that afternoon. So I am just waiting for Queensland to jump on board, but this is the system that we've got at the moment. It is very paper-based. And it is also quite difficult to explain to clients, yeah, cool, we can file this. We might not have a grant for 2 months. So something to keep in mind, managing those expectations, but also making sure that when you're completing your application, you have all of the information, and always get it triple checked if possible. Just a tip. Anyway, I've gone a little bit over time, but I hope that that's been somewhat useful just to see what you would actually be doing in practice and the forms to use. They are all online. So if you do want to go back through in a little bit more detail and have a read, jump online, forms section, wills and estates, and all the forms are in there. Your affidavits for your letters of admin with will and letters of admin on intestacy are all there as well. Very quickly, any questions about what we've covered? Nope. All right, guys. Well, thank you very much. And sorry that we've gone over a little bit tonight. I'm planning on sort of a big catch up this weekend. So if you do have any questions, send them through to me. I've set some time aside this weekend, and I will pop up just what we covered with respect to assessment 2 in the announcements or general discussion as well. So everyone's got that. Have a great rest of the week. Thank you all, and I'll see you next week.
Thank you.
Thanks,
Bye.
Arabella.
Oops.
Thanks, everyone. Next week.
Bye. Oh God. What have I done? Sorry, Luke, I'm having dramas.
Oh, yeah. All right, I'll just leave then.
Yeah, just yeah. Thank you.
See you next week.
Yeah, bye.
Bye.
Oh, cool. How do I stop? Oh, I've done something.